Difference between public and private nuisance. Introduction. Public nuisance and private nuisance are two branches of the tort of nuisance. The distinction is important because they differ in nature, persons affected, remedies and procedural requirements. Public nuisance affects the community or a class of people, while private nuisance affects an individual's use or enjoyment of land. Understanding this difference is essential for LLB examinations. Public nuisance. Public nuisance is an unlawful act or omission which interferes with the rights of the public at large or a considerable section of society. It affects public health, safety, morals, or convenience. It is both a tort and a crime. Generally, an individual cannot sue unless he proves special damage different from the public. Persons affected. The public or a class of persons is affected rather than a single individual. The injury is common to all members of the community using the affected place or right. Nature of action. Public nuisance is punishable under criminal law, and civil action is allowed only on proof of special damage. Case law. Attorney General vs. PYA Quarries Limited, 1957 Facts. The defendant operated stone quarries which caused excessive noise, vibrations, and stones flying onto public roads and nearby houses. A large number of residents and road users were affected over a wide area. The disturbance was continuous and serious. The court held that the activity amounted to public nuisance because it materially interfered with the reasonable comfort of a class of the public. An act affecting a section of society constitutes public nuisance. Private nuisance. Meaning. Private nuisance is an unlawful and unreasonable interference with a person's use or enjoyment of land. It affects specific individuals rather than the public at large. The interference must be substantial and not merely trivial. The right protected is a private property right. Persons affected. Only a particular individual or a limited number of individuals are affected. The injury is personal and specific. Nature of action. Private nuisance is purely a civil wrong. The affected person can sue without proving special damage. Case law. Sturges vs. Bridgman, 1879. Facts. The defendant used noisy machinery in his confectionery business. The plaintiff, a doctor, built a consulting room nearby, and the noise interfered with his medical practice. The disturbance affected the plaintiff personally. The court held that the noise amounted to private nuisance. What is reasonable depends on the locality, and prior use by the defendant was no defense. Key points of distinction. Right affected. Public nuisance affects public rights. Private nuisance affects private rights relating to land. Remedy. In public nuisance, action is usually taken by the state or with proof of special damage. In private nuisance, the affected individual can directly file a civil suit. Criminal nature. Public nuisance is both a tort and a crime. Private nuisance is only a civil wrong. Proof of damage. Special damage must be proved by an individual in public nuisance. No special damage is required in private nuisance. Conclusion. The difference between public and private nuisance lies mainly in the extent of interference and the persons affected. Public nuisance protects community rights and public welfare, while private nuisance safeguards individual property rights. Courts apply different rules and remedies depending on the type of nuisance involved. This distinction is highly important for LLB examinations and practical application of tort law.